Thanks so much for being with us today.
Thank you so much, everyone. I'm actually going to use this just so I can put stuff down, and also, even though it makes me look shorter than I am, and I'm already pretty short, I'm just going to put my timer on because I'm also awful with time in general. But I'm really excited to speak to you all today. It's something that I've been thinking about for a long time. After the 2012 election, I kind of got started on this train of thought, and especially over the past year, I've been thinking a lot more about this. And I hope to be able to explain some of what went wrong in the GOP and some of the path forward that I think would be good for all Americans. I believe the future of the GOP as a principled party, not as just a populist or winning party, because I think there's more to politics than winning, is of judicial engagement and of cities. What happened in the GOP in 2016 is not okay. It's unthinkable that the GOP elected a man who takes pride in belittling people, let alone a man who supports neither the GOP's nor the Constitution's values. Like many Republicans, only a few years ago, I would never have expected to see a man like Trump as the nominee, let alone as president-elect. I don't think he represents something good, but I obviously hope and pray he serves America well. I've stood firmly against him for well over a year now, and I intend to continue to oppose bad actions he takes and support good ones he takes. Despite his win, I don't think he's the model for a sustainable GOP. And even were it a sustainable model, there's more to politics than winning. How you win matters. Principles and integrity matter. I understand some of what led us here. Part of the reason I didn't quite see it coming is that I saw the GOP's highest potential and what it could be. I still see it, and I know some of what needs to happen to get us there, though I don't have all the answers. The many good and reform-focused elected Republicans suggest reason for hope. So some of the reasons Trump was nominated. Republicans have long embraced talk radio, which isn't all bad. There's some really great hosts. But Republicans and talk radio listeners long ago forgot it's a business based on money and often faux principles. Talk show hosts are paid for the popularity of their words, and oftentimes being provocative and even downright untruthful makes more money. This election cycle, the talk radio infrastructure built up with the help of many Republicans burned Republicans in the primaries. Another reason is that politicians make and break promises. Many believe that such behavior is inherent in politicians. It often seems that way, but years of overpromising and under-delivering has hurt both parties. The Tea Party movement started in part because people were tired of not being able to trust their elected officials. Unfortunately, the politicians who they elected continued the same trend. This year, many frustrated voters understandably turned to Trump for help, as they once turned to Tea Party candidates. Trump has done quite a bit of overpromising himself, which will not serve him well in the long term, nor will it serve other politicians well who choose to do the same. I don't mean to suggest that all politicians who overpromise and underdeliver do so with bad intentions. Many believe it's okay to sacrifice some honesty in the means if it's good for the ends. It's the ends justify the means thinking. I do not believe that to be the case, and I do believe such actions hurt credibility and trust, as 2016 has demonstrated. Republicans need to do a better job of resisting the temptation to embolden counterproductive talk show hosts and to overpromise, both of which are harmful in the long term. It is easier said than done, but many on the right have realized that they must embrace the integrity of their actions if the GOP is to survive and exist as a party based on principles. Today, I want to talk less about these more obvious and more complex actions that the GOP needs to take and should have been taking for a long time. Done well, I think these approaches might have stopped Trump from being nominated. They can certainly do a lot of good for the GOP's future and for America's future. Among the changes the GOP must make are no longer ignoring cities, more fully embracing our founding principles, and including more heart in our messaging. Thankfully, there are quite a few elected Republicans who understand and show willingness to embrace this kind of thinking. So Republicans have long ignored cities, and the reasons why are mainly false premises. What unites the GOP in principle includes free markets, the Constitution, and the promise of opportunity. These are principles too often absent in the leadership of city governments. It's no wonder few Republicans hold elected office in cities. Only 13 of America's 50 biggest cities have Republican mayors, and only 3 of the biggest 25. And it's not because city governments have been perfected by Democrats. They haven't, or because people don't want competitive leadership. They do. To understand why, I'll note a personal experience to which many other Republicans can relate. I got involved in politics when I was 14, and I did a lot of campaigning. And through my involvement, I learned that campaigning in cities was not worth the effort. Common wisdom stated that people in cities won't vote for Republicans and don't want conservative solutions. And that was the norm, and I never thought to question it. It was also a false premise. A few years ago, and the first time I really thought about this objectively, a friend came to me with the idea of working to change the way Republicans see cities. It began with a lot of research, and it became a side project that we called City GOP. Over time, we found that Republicans hadn't really been trying to win cities, nor had they been making their cases effectively to people in cities. Every place is different, and candidates have to address people's local concerns. That hasn't been happening for Republicans in cities. Republicans' distance from cities stems in part from an irrationally negative view of cities, a false premise. A Prescient article in 2014 from Matt Lewis considers how conservatives often refer to places of low population density as real America. He notes this contradiction within conservatism. He says, much of conservatism, free markets for instance, is premised on the notion that more people equals more ideas. This, of course, is inconsistent with a more traditional populist strain of conservatism. Unfortunately, that strain took hold of the party in 2016, but the first strain ought to be embraced. Cities are beautiful places with lots of people, creativity, and innovation, things that work perfectly with a free market view. However, many hold the view that cities are centers of immorality and elitism, that they're inferior to rural areas. Lewis explains that much of the belief in rural superiority has roots in misunderstandings of religion, philosophy, and America's founding. So even though a big chunk of the romanticization of the rural and the distrust of the urban is not based on facts and logic, it has had an enormous impact on the party. Another false premise is that cities don't want competitive or conservative leadership. It is important to understand the key role population density plays in Republicans' difficulty in cities. Republicans ignoring cities is such a big problem that, well before this election, red-blue maps of America looked almost identical to population density maps. Take a look at 2016's red-blue and population density maps. They're very similar. In my research for City GOP, I repeatedly found this to be the case with rare exceptions. We found a study that showed Republicans perform well in areas containing fewer than 800 people per square mile. In any area with higher population density, Democrats perform better. The further from 800, the better each respective party performed. Needless to say, cities are growing and will continue to grow. As the author of the same study puts it, red states are just underdeveloped blue states. And for no other reason than basic math, Republicans cannot afford to ignore cities and ought not to have been ignoring them for so long. One of the best examples of a statewide Republican who bucked the trend was Governor Chris Christie. And I know 2016 definitely put him in a different light and behind Trump. But in 2013, Christie won some of the most densely populated counties in New Jersey. There's plenty of articles written about Christie campaigning in urban areas. For instance, one quote from an article in Real Clear Politics hit me. A Democratic voter said of Christie, "How many Republicans are you going to see walking up and down these streets like this? He's approachable. I really like that. And I think people in Orange are really thrilled, whether they're Democrat or Republican, that he's here." Christie showed up and showed he cared, and that made all the difference. You'll find quotes like that about other Republicans who performed better in cities, such as Illinois Governor Bruce Rauner and Maryland Governor Larry Hogan. Massachusetts Governor Charlie Baker spent a lot of time campaigning in cities and rolled out a conservative urban agenda during his campaign. At the time, Baker said his plan was about closing the opportunity gap. He said, "These are not Republican, Democrat, or independent ideas." Of Baker, one man said, "Charlie shows up. He's there, in the batting cages, on the fields, walking the streets." Again, walking the streets. Baker understands the importance of campaigning in cities. The governor himself said you have to make the sale, but you can't make the sale if you don't show up. The state GOP has also done a lot of work in cities. Republican San Diego Mayor Kevin Falconer recently won re-election with 58% of the vote. He was first elected with 53% after his Democratic predecessor was immersed in scandal. City Journal notes that he campaigned for market-based policies, such as competitively bidding out public services and against union-backed efforts to force contractors to pay prevailing wages on government-funded construction projects. He focused on conservative solutions to local issues, and it worked. Conservative advocacy group, the Libre Initiative, focuses on the Hispanic community. In 2014, Libre's Daniel Garza told a Tea Party group, "For decades now, while we've been absent, while we haven't engaged with the community, the left has. It's important that we gain the trust of all of the community so they know that we're partners in helping them develop, prosper, to assimilate, to contribute to the American economy." Libre's Brian Fognan told me that the group's staff and volunteers are dedicated to the prosperity of the community and to sharing our ideas about limited constitutional government and free markets. And as an organization that is going to be there for the long term, we have developed the trust of the community that we will do our best to work for their best interest. When Republicans or any politicians or leaders in general show up to listen, talk about solutions, and work with communities, it makes all the difference. Another myth that I'd long been told in order to lead in cities, conservatives would have to compromise their values. From my research at City GOP, that's just not true, but it's a refrain I've heard many times. Cities, like states and other localities, serve well as laboratories of freedom where innovative solutions can be tested. And some of the best and most successful solutions, from charter schools to occupational licensing reform to housing policy, are conservative and free market in nature. They are based on the ideas of small government, freedom, and competition, all values conservatism embraces. But it is important to keep in mind that not every solution is right for each city. Different places face different problems. That's why it's so important for Republicans to focus on the concerns of the people in each area, what issues exist, and what solutions could fit. Additionally, single-party rule in any area is never good. When politicians know they're going to win without much competition, they take votes for granted. Republicans need to compete in cities and show they value voters. Even if they don't win, at least it will make politicians actually compete for votes, which benefits the people. Basic math and reason ought to compel Republicans to work towards winning cities. The reasons Republicans have avoided cities don't make sense. Cities need competitive and conservative leadership, and cities are growing. Republicans must listen and engage in cities. A part of that must include telling people stories and relating them to policy solutions. One group has already been the model for this: the storytellers and the litigators, the Institute for Justice. The Institute for Justice, or IJ, has long been doing what Republicans should have been doing, bringing freedom-oriented solutions to cities and doing it with principle and with heart. IJ is a nonpartisan group. They regularly work with organizations, both on the left and the right, such as the ACLU and Americans for Prosperity. They're brilliant nerds who litigate on behalf of the little guy when he's hurt by government, but the way they tell the stories will break your heart. IJ also famously litigated against Donald Trump when he tried to take an elderly widow's home by abusing eminent domain to build a limousine parking lot for his casino. Eminent domain, when government takes a person's land and fairly compensates her for it, is supposed to be only used for public purposes, not limo parking lots. IJ won the case for her, so he doesn't always win. Among the most important examples of IJ's stories is that of Sandy Meadows. I'd like to read you her story, and I hope it impacts you the way it impacted me. This is an excerpt from an article by her lawyer, Clark Neely, who serves now as the director for IJ's Center for Judicial Engagement. Sandy Meadows was a widow who lived by herself in Baton Rouge and loved working with flowers. She had little education and nothing in the bank when her husband died. She'd never had to support herself before, and her only vocational skill was making floral arrangements. Unfortunately, Louisiana is the one state in the country that licenses florists, just like doctors or lawyers. Sandy tried 5 times to pass the licensing exam, but it was too subjective. Besides taking a written test, applicants had to make 4 floral arrangements in 4 hours. A panel of working florists would grade the arrangements and decide whether the applicant was good enough to set up shop and compete with them. Usually they said no. When the agents of the Louisiana Horticulture Commission found that Sandy was managing the floral department of an Albertsons grocery store without a license, they threatened to shut it down. The store had no choice but to let her go and hire a state-licensed florist instead. Prevented by government from doing the only work she knew, Sandy had no way to make a living. She had no car, no phone, and on the last day I saw her alive, no electricity because she couldn't afford to pay her utility bill. In October 2004, Sandy Meadows died alone and in poverty because the state of Louisiana wouldn't allow her to work in a perfectly harmless occupation, and I couldn't persuade a federal judge to protect her right to do so. This is outrageous, unjust, and unconstitutional. That's from Clark Neely. This kind of thing should never happen, but it's far too common, and thankfully IJ is there to litigate on behalf of the little guy when he's hurt by absurd government regulations like this. The GOP should be among his most vocal champions, and not on the wrong side of IJ's litigation. Many are unfamiliar with the corruption too often present in occupational licensing, a type of regulation that usually purports to protect public safety, but is regularly all about protecting monopolies. Of course, we want doctors and other people employed in life or death professions to have licenses, but florists? Neely explained in an interview what was really going on in Louisiana. He says, quote, "That law was obviously enacted for the purpose of suppressing competition and enabling industry insiders to keep out newcomers. But given that it's a rational basis case, of course the true reason for its enactment is relevant to the court. And so the government lawyers got to make up any explanations they could think of. And as the government typically does in a rational basis case, they tried to come up with a health and safety argument. In other words, that the law was perhaps enacted to protect the citizens of Louisiana from the dangers of unlicensed floristry." I love Clark, he's a good guy. This is preposterous, of course, but it's a rational basis case, so that doesn't matter. And among the things they mentioned as possible concerns with unlicensed floristry were, don't be scared, misplaced corsage pins, the possibility that floral wire, which is used to hold the stems together of a bouquet, if improperly installed, could come unsprung and get entangled in the bride's gown, and then she could trip in the aisle on the day of her wedding, and that the bride would be very embarrassed. This was actually said to me by someone under oath who worked for the Louisiana Horticulture Commission. And then, of course, there's the specter of, quote, infected dirt, which is actually cited by the judge in upholding the law. Infected dirt. I don't know to this day what that dirt was supposed to be infected with or what good it would do to require people to pass an exam that has nothing on it about infected dirt. But the judge apparently felt otherwise and upheld the law partly on that basis. Again, that's from Clark Neely. As I mentioned earlier, Neely heads IJ's Center for Judicial Engagement. To understand why regulations like these are upheld in court, you have to understand what judicial engagement is. Most of you have heard about judicial restraint and judicial activism. IJ, myself, and others are proponents of a third way called judicial engagement. We believe that all rights deserve real protection is a concept enshrined in the Constitution. Unfortunately, too few judges believe it. Though many praise restraint, it is not a virtue. On a superficial level, you'll hear restraint and activism used interchangeably with good and bad, with no underlying consistent principle. If one likes a court's ruling, the court used restraint. The other side will be angry the court used activism. Judicial restraint is often understood as judges avoiding striking down laws, even if they're unconstitutional. This theory also praises when judges defer to the legislature on issues of constitutionality, as though the legislature ever considers it. I ask you, when was the last time you heard a member of Congress earnestly question, wait guys, was that law constitutional? That doesn't happen. It should, but it doesn't, and this is why we have courts, to make sure laws are constitutional. Engagement proponents believe the idea that courts' refusal to do their job is nonsense and an abdication of their duty to uphold and protect the Constitution. Rather, we believe courts must say no to government if government acts unconstitutionally and the case comes to court. As Neely explains, in many cases, they're not really making any serious effort to determine whether the government's action is in fact constitutional. Instead, they're starting with what amounts to a predetermined belief that the government's action must be upheld and that their job is to sort of reason backward from there. Judges often put their fingers on the scale of justice to tip it to the side of government. Some call that the presumption of constitutionality. That is, the idea that courts should assume the government is acting within its constitutional bounds and make those who brought the case to court against government prove otherwise. We believe the burden of proof should be on government to justify its actions. If it acted to protect public health or safety, the government should be able to prove its intentions. If it can't, that's a problem. Oftentimes, in cases IJ litigates, one will find if the government can't prove it acted for a constitutional reason, the reason is that it didn't. Think of it this way. Government officials know that if they say what was really an act of corruption was done for public health or safety, people are less likely to question their actions. That's why courts must not err on their side and instead seek the true reason for their actions. Republicans ought to do more of that in Congress and state legislatures too. Another facet of judicial engagement is that all our rights deserve protection, not just those written down in the Constitution. Do you know why our rights written down in the Constitution get more protection than those that are not? Are they more important? Did our founders say that's how it works? None of the above. Neely explains that the root of the misunderstanding is from a 1938 Supreme Court case in which the court, quote, asserts the idea that some rights are fundamental and entitled to meaningful judicial protection, and those are basically rights contained in the Bill of Rights and perhaps one or two others. And then every other right you might think of, and that includes everything from the right to earn a living to the right to seek potentially life-saving medical treatment, neither of which are specifically mentioned in the text of the Constitution, should be considered non-fundamental rights, and that they are not entitled to any meaningful judicial protection. That's it. But if you read the Ninth Amendment, something we judicial engagement proponents love, it says, quote, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." That sounds pretty clear to me. Even though proponents of expanding government power beyond its constitutional bounds have ignored this amendment, it is still in the Constitution and it still means exactly what it says. As IJ's website explains, the Ninth Amendment recognizes that rights not written down in the Constitution are, quote, "retained by the people. All of these rights are to be protected by government and may not be infringed, even by majorities acting democratically." Constitutional scholar Professor Randy Barnett has written at length about this issue, most notably in his paper, quote, "The Ninth Amendment, it means what it says." In that paper, Barnett cites James Madison's precursor to the final text of the Ninth Amendment. Of that precursor, Madison said, quote, "It had been objected also against the Bill of Rights that by enumerating particular exceptions to the grant of power, it would disparage those which were not placed in that enumeration, and it might follow by implication that those rights that were not singled out were intended to be assigned into the hands of the general government and were consequently insecure. This is one of the most plausible arguments I have ever heard urged against the admission of the Bill of Rights into the system. But I conceive that may be guarded against. I have attempted it." Madison, among others, understood if a list of rights was added, some might think rights not written down were allowed to be violated by government. The whole point of the Ninth Amendment was to make sure nobody thought that. But as we know, government likes to expand its power, so the courts give our unenumerated rights less protection for no constitutional reason. All of this applies to the states via the 14th Amendment, which, quote, forbids states from abridging the broad set of principles, the broad set of privileges or immunities, meaning rights, held by citizens of the United States. The survival of individual rights also necessitates judges using judicial review, a process that is included in the original meaning of judicial power, according to Barnett. Without judicial engagement, courts may, and all too often do, decide that your unenumerated rights don't deserve real protection. These judges don't consider the legislature's true purpose in passing law, whether it be legitimate or illegitimate, health or corruption, public safety or racism. With judicial engagement, courts seek out the truth. Was a law passed to protect public safety, or were they just trying to restrict competition that might have affected a friend's business? This understanding of the courts and the Constitution is a necessary foundation for much of IJ's litigation. Embracing such an understanding would move the Republican Party in the right direction towards liberty and away from authoritarianism and what Trump has preached. It would also reduce IJ's caseload by advocating for people hurt by corrupt laws and deferential judges. As you started to see, real people are hurt when government doesn't defend constitutional principles such as the ones IJ defends. Now that you understand how judicial engagement works, I want to show you what happens when it's applied to people. In the case of Sandy Meadows, her right to make a living, which isn't written in the Constitution, was not protected. So government made up crazy reasons why florists needed to be licensed, and the court didn't care about the truth. If they had, it would have been obvious that the license did nothing more than protect florists from free market competition, and Sandy Meadows might have lived a longer life. In a lot of states, you need a license to braid hair. That's right, that thing you do for your daughter. This has been a big problem for African-style hair braiders. Thankfully, IJ has taken up numerous cases in different states. As IJ's website explains, quote, to braid hair for a living in Iowa, the state forces braiders to spend thousands of dollars and hours for cosmetology training that has nothing to do with African-style hair braiding. Instead of getting their businesses off the ground, Iowan hair braiders are tangled up in senseless regulations. In order for IJ to succeed in their litigation against these kind of regulations, courts need to take their unenumerated rights seriously. IJ cases on behalf of eyebrow threaders are very similar and very common. Local Republicans ought to work to remove these regulations. Another common type of IJ client is food truck vendors. In many states, food trucks can't operate within a certain distance of restaurants. The obvious reason is to prevent competition. This hurts consumers, food truck vendors, and it only helps restaurants. Even more bizarrely, some states license storytelling, what I'm doing now. In Savannah, Georgia, tour guides were required to obtain a license. Quote, unlicensed storytelling risks fines of up to $1,000, 30 days in jail, or even forced participation in a municipal work gang. To obtain a license, one would have to pass an exam that might have nothing at all to do with the subject of their tour. They had to pay an annual licensing fee and had to go and undergo a criminal background check. Tour guides were even required to undergo a physical exam by a doctor to determine whether they were sufficiently healthy to exercise their First Amendment rights. Yes, in Savannah, the government could declare a tour guide too unhealthy to talk. Thankfully, that law was repealed, but there is still a tax on tour guides. For every person that they have on a tour, guides are required to pay a $1 fee to the city. Then there are cases taken up by IJ on behalf of new taxi and ride-sharing companies that local governments have not allowed to exist. The government of Little Rock, Arkansas upholds a taxi monopoly by only allowing new taxi permits to be issued if public convenience and necessity leave no other choice, and if doing so will not harm the existing permit holder. That's wrong, and it's unconstitutional. However, it is impressive that they didn't even bother to pretend the actual issue was public health or safety, so I gotta give them that one. One thing that a good deal of IJ's cases have in common, the clients live in cities, and in all of these cases, Republicans ought to be their advocates. We saw Republicans embrace competition as it relates to Uber and ride-sharing, but that's just the tip of the iceberg. Imagine a GOP that worked to promote the same liberties as IJ, but through the legislature instead of the courts. How great would it be if state legislatures didn't pass these regulations that hurt people, so IJ wouldn't have to litigate their cases? In July, Senators Ben Sasse and Mike Lee introduced occupational licensing reform legislation that they hoped could be the model for states. In a speech at Heritage, Sasse recounted the story of Ego Brown, who ran a shoe shining operation in Washington, D.C. Brown employed homeless people who needed jobs and needed to learn skills. Unfortunately, he didn't have all the right licenses to shine shoes. And as Sass said, today in DC, to be a shoe shiner, you have to have 4 different kinds of permits. You have to have a criminal background history. At least one of these is clearly legitimate to me, which is you have to demonstrate to DC that you've done all the paperwork so you can pay taxes. You have to pay a technology fee to be a shoe shiner in DC, and there's some 4th fee. And the total cost of those is $337. But that only licenses you to shine indoors. There are separate rules if you want to shine shoes out of doors. Quote, and back in 1985, Ego Brown didn't know those rules, and so he was shut down. Brown had to go back to working inside barber shops, which was not as profitable, and his business struggled. He eventually sued the DC government so he could be allowed to shine shoes on the street. Brown won that 1989 case. Unfortunately, that only took care of one problem. More recently, a DC student learned about all it takes to shine shoes here, including the need for a $1,200 sidewalk permit. Brown's lawyer was Clint Bolick, who later co-founded the Institute for Justice. Bolick was also appointed by Governor Doug Ducey to the Arizona Supreme Court earlier this year. It was heartening to see Sass and Lee focus on this story and this kind of policy. We need more of this. And in conclusion, I'd like to kind of bring this all together. Republicans need to talk about regulation reform and free markets. That's a good start, but we need to do better. Like IJ, Ben Sass, Mike Lee, and others, we need to tell the stories of the real people regulations and anti-competitive measures hurt. We need to tell Sandy Meadows' story and Ego Brown's story. Quote, regulation reform should be a story, not just a talking point. Free markets should have faces and not just policies. We need to show who is hurt when the Constitution is ignored and take IJ's principles to the other branches of government. We also need to seek out those who are hurt by government and work to right those wrongs. Principles, integrity, heart, and policy work together in harmony. IJ is the model, and its heart and stories are inseparable from its principles. Their means are worthy of their ends, and the GOP's ought to be as well. We need to apply this to all places, especially cities. We need to invest in cities, campaign in cities, and listen to real people in cities. We should be advocates for people hurt by cronyism and arbitrary government, much in the same way as is IJ. The most powerful way to communicate the problem is through individual stories and through defending rights with as much heart as IJ's staff does. I realize this only covers a relatively narrow set of issues, but imagine what could happen if we took this kind of constitutionalism and storytelling to all of the issues. Less talking and more sympathizing, humanizing, and storytelling. Principles instead of platitudes, reason instead of false premises. And with all this, means worthy of their ends. Trump and his coattails have limited potential and the wrong principles. Consider what is possible if the GOP instead embraces all that I've described here. The GOP could embrace free markets and the Constitution while once again becoming politically competitive in cities, helping cities grow, and encouraging all people to achieve their highest potential. Thank you.
Thank you so much, Shoshana. That was some wonderful food for thought. I think we can all agree that the integrity, heart, I mean, those are things that are definitely non-partisan. We have a good deal of time actually before our break, maybe 30 minutes or so, and then a break and then into lunch. So lots of good time for Q&A. Who would like to start us off? And I think with the small, I've got a microphone.
I'm pretty loud.
Okay. We can all use our voices.
I think this is a great point. I'm pretty familiar with IJ's work, but there's so many more stories beyond what they really do. And I think that the point that this is uniquely applicable to cities makes a lot of sense. But what's hard for me is to connect the two. I'm in a lot of meetings and conversations about reg reform. Everyone's really big about regulation reform, and it's really important. It seems entirely separate from this really good, effective storytelling. And I don't know how to get the same people in the room to do those things. And we have great examples and we have people that can do it. and it makes a lot of sense. I just, the how you do it seems like the hardest question, so that's the one that I'll pose to you.
Yeah, you're absolutely right, and I've been in many similar rooms. I love regulatory reform. I'm such a dork for it. I'm a giant nerd at heart, always. But IJ is actually kind of what got me there, because I think if you hear these stories, you kind of have to like fall in love with it when your heart breaks for these stories. I think a big part of it is getting the loudest voices there, so I was really happy with Ben Sasse. He's been very, very heartening in all that he's done, and Mike Lee too. And we have some other senators and leaders who are doing really well with this, and even for Ducey to nominate Bollock to the Supreme Court was a really big step. So these are all really good steps, and I think we just need more of that. In the primaries, actually, I liked Rand Paul a lot because he was focusing on all this. I met with him, and he loves IJ, he loves judicial engagement, so we nerded over Randy Barnett and all that stuff. And I think one thing I wish he had done more of is on like the debate stage, and when he had the biggest audience to talk about this stuff and maybe tell a short version of the story. And I think that's something we really need to do better with, because you know, people always talk about how liberals show more heart and Republicans seem more rigid. You're right that storytelling is a really big part of it, and I think in order to get it done, a big part of it has to be that we have to show it's politically advantageous. And IJ, you know, the judges make their own decisions, but it certainly helps because, you know, judges are influenced by public opinion when IJ is going out and telling these stories to people, so people know about the case and they know about the poor person hurt by the case. So if that can happen even in the courts, I think we can show them, look, IJ benefits from this, you can too. And unfortunately, I wish everyone just did it out of the good of their hearts and integrity, but if we can't get it on that alone, hopefully at least showing that it's politically advantageous. And that's part of the case I'm hoping to make here, and hoping to see for legislative assistants and other people who work with big people to see that, you know, that these stories are part of winning. That if you want to win, and if you want to win on principle, or even if you just want to win, you know, this is how you do it, by telling these stories. I remember the first time I heard Sandy Meadows' stories, I was almost in tears, and embarrassingly, because I was just in the audience listening to him, and Clark's become my favorite person because of that. And I'm hoping that Republicans see that, and Democrats too. That would be great if Democrats embrace this stuff as well, that these stories matter and that people are really affected by them. But instead, we often see people just saying regulatory reform, and only I get excited when people say that.
Do we have other questions? All right, well, join me in thanking Shoshana.
Thank you. Oh, thank you.